All right, let's get started. People will be trickling in over the next couple of minutes, and we will let them in shortly. First off, thank you for joining this webinar today. My name is Ben, and as the host of this session, I will be moderating the discussion. Our goal today is to familiarize yourselves with the ins and outs of becoming an expert witness, and we hope that you find this webinar helpful. We are streaming live out of Houston, Texas, and joined remotely by a few of our expert panelists and all of you watching today. Good morning to you all.
Morning.
Before we go further, if you have any questions during this webinar, feel free to type them into the chat. We'll try to answer them as we go and during the Q&A session in the later hour. Our first speaker is my amazing business partner and CEO of Cambium Consultants, Annette Santamaria. Janelle has worked with top firms such as Quinn Emanuel, Orrick Harrington, and Norton Rose Fulbright, recruiting experts for high-stakes, complex litigation. She has an executive MBA from Cornell University and a BA in communications from Baruch College. Janelle, I hand it off to you.
Thank you, Ben, and welcome to everyone who's joining us either here in person or remotely online for this webinar. And our goal here is just to give information about this industry, what it takes to be an expert witness, how you find opportunities, what the work is like, and other questions that may arise as we are going through this presentation. So I'd like to give an overview on, a few factors, 4 factors actually, that are important that we use to screen experts to determine suitability for a matter. The first one is the responsiveness of the expert. And it's very, very important that if someone ever reaches out to you for the first time, you've never done it, you're actually, the screening starts from the minute that you get you on the phone. Can we ask that everyone mute your mic? If you're on the webinar, if you can mute, that would be very helpful. And so being responsive is very, very important. So how quickly do you respond to emails? Do you get back to, or voicemails? Usually we're looking for a response rate of no more than 24 to 48 hours. If there's a delay, the assumption is in the middle of the case that you may take as long, which when there are tight deadlines is something that can cost, the results of a case. And so it's something that is very, very important. Punctuality. If you're showing up to the meeting, literally 2 minutes, 1 minute, you're late. And that has as much as an impact in evaluating your suitability as how long it takes you to respond to an email or a voicemail or any kind of communication that's sent to you. It's very, very important that time is treated with the respect that's needed, because when it comes to litigation, time is money. Decisions need to be made that could impact the outcome for a company or an individual that have lifelong, sometimes disastrous effects if everything isn't managed well. And as well as for how prepared are you? Did you read the material that was sent to you before an interview? You're prepared. You've looked at the information, you've done your stuff, that you are responsive and prepared for being able to work on this matter. The second type factor is the type of court. And we say this because depending on whether or not the case is being litigated in a court that has a jury trial, that's a persona of an expert. We need someone who's personable, who can communicate complex matters to someone with an 8th grade education, 8th grade level education. Sometimes there are trials that are held in courts like the International Trade Commission, which is located in Washington, D.C., and that's a bench trial. What that means is there's no oral testimony, everything is written. So the persona of the expert that's retained for a matter in any type of case where there's a bench trial, we're looking for the credentials, the publications that's been made, the reputation, like deep reputation in the industry that this person is in, because it really becomes a battle of the experts, because the whole case is decided on the written submission and the written reports of these experts. And so that person doesn't necessarily have to be the one who can speak well to, an 8th grade person, because even the judges in that court, there's someone who's called a special master intelligent judges, intelligent support staff is evaluating the content that's being presented to them to determine the outcome of the case. The third factor is presence. I cannot tell you how important this is. It pays to be nice. It pays to be nice. And from the time you're interviewed, and I'll tell you, this is what I've done. I've interviewed many, many experts. I've interviewed everyone from automotive engineers to aerospace engineers, to physicians, doctors, to, I've covered the gamut of industries. And the first thing, from the minute I say, hi, how are you? I'm looking to see how you're communicating and interacting with me. When someone says, or takes a position that, yes, I'm an expert, I know it all, I'm the best, I can tell you, you're almost automatically written off. Because a good expert, the right expert, knows what they don't know, not just what they know. And they're willing to speak about that and just that and feel comfortable to say, you know what, though I'm familiar about X, Y, and Z, I don't consider myself an expert. Your presence and how you come across can sway a jury because people are not logical, and we know this. And so if you're presenting to a jury and your presence comes across as overbearing or condescending, even if what you're saying is right and accurate, it's probably not going to be taken into consideration. Interrupting, speaking too much, all of that is something that is paid attention to, and it's crucial that that as an expert you understand listening and responding to what's being asked of you. If you have a thick accent, that's not usually a problem unless you're unintelligible, like you cannot understand what you're saying. Regional dialects probably will help. For example, in Texas, right now we're shooting out of Houston, and in the Texan courts, believe it or not, it is very difficult for me to place an expert in a Texan court that's not from Texas. It's very, very challenging because the jurors, and this has been documented and studied, prefer to hear testimony from someone who is from the region. So sometimes that helps, and that may determine who is better for a matter over another. And the last part is the specificity of expertise. We can have two similarly qualified experts, and this is why I put it on the website for anyone who's joining us. If you've created a profile, we ask that you put everything that you have worked on. Unlike applying for a job, when you're being recruited to be an expert, we're looking backwards. We're looking at the depth of what you've done in the past, because you're not coming to move us forward. You're coming to give testimony and opinions on something that has happened based on what you have done. And so two similarly qualified experts, one person may have worked on one particular project that another did, that would then make that expert better suited for the matter. It's very, 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 very specific. And so it doesn't mean that the other person isn't a good expert. It just means that this one's better suited because they just happen to have that experience on whatever that matter is that's being litigated. And so these factors, these four factors, responsiveness, the types of court, the presence, and the specificity of expertise all go into selecting who is appropriate for any given matter. Thank you.
Thank you, Janelle. We will be diving into the attorney's perspective next with our next speaker, Kevin Baer. Kevin is a partner in Norton Rose Fulbright's Los Angeles and San Francisco offices. He has litigated and tried cases in multiple federal, state, territorial, and tribal courts, as well as before government agencies and administrative bodies. Kevin has a JD from University of California, Hastings College of the Law, and a BA from University of California, Berkeley. Thank you for joining us, Kevin.
Ben, thank you so much. And Janelle, thank you for giving me this opportunity today. Good morning, ladies and gentlemen. It's a pleasure to be with you today. We're going to talk about what it means to be an expert, what an expert witness actually is, and what some of the criteria and characteristics are that will guide the work that one is performing as an expert. And I thought it would be useful to start with a few wry observations from some of history's great philosophers that we'll put up here on the screen for you all to see. And I'm not going to read these for you. You can take them for what they're worth. But it's extremely important to understand what an expert witness is. And by definition, an expert is someone who, by virtue of special education, training, and experience is deemed by a court to be sufficiently qualified to engage in an independent and objective evaluation of the evidence in a case, both documentary and testimonial, and to arrive at opinions and conclusions about disputed fact issues that are going to be submitted to the jury for determination. It's important to understand that in any trial, whether criminal or civil, the court is the trier of the law. The court decides what the law is and will instruct the jury accordingly. The jury, by contrast, has the job of determining disputed fact issues in order to arrive at a verdict on those questions that are submitted to them for decision. And as we'll see, in most civil and criminal cases in modern jurisprudence, expert witness testimony is required. Let's go ahead, Ben, to the next slide if we could. So let's then talk about what expert testimony is. And we provided here for you the legal jargon, the terminology that we actually use in the law to describe what this is. At bottom, an expert is in court to testify about a subject that is sufficiently beyond the common experience of the jury. Jurors are typically made up of lay people. Many have no more than a high school education. Some will have college, some will have advanced degrees. But by and large, these are lay people who need to hear evidence and testimony from someone that is bringing a particular expertise of relevance to the case. And the court has determined that this subject, in being sufficiently beyond common experience, requires an expert to offer opinions that will assist the jury in deciding the disputed issues of fact that are submitted to them for decision. The expert's testimony must be based on matters that are either perceived by or personally known to the expert as a consequence of their special education and training and experience. And it must be of a type that the expert may reasonably rely upon in their particular field on that particular subject. And these terms all have meaning, and indeed there are many appellate decisions that have gone into the interpretation of these terms in deciding whether or not an expert is qualified to offer their opinion at trial, whether they should be permitted to offer the opinion, whether that opinion is based on proper or improper matter, and ultimately whether it should be given entirely or in some respects perhaps not entirely to a jury in any particular case. Let's go on, Ben, if we could. Now, expert testimony is required when either evidence on the claim that has been brought by the prosecution in a criminal case or the plaintiff in a civil case, or in support of a defense that is being offered by the defendant, requires evidence that is beyond the lay juror's common knowledge. That is the knowledge that we all have simply by virtue of being alive. And so we provide here for you some examples of when evidence through expert testimony would be required in certain types of litigation, because these are not areas that the common juror will have a ready understanding of, even though they may have done some reading, they may have some lay understanding of the situation, but it's not sufficiently complete. And therefore, we bring an expert to the courtroom to talk about these sorts of issues. Very few people understand why it is that a particular exposure to a chemical compound might be associated with or cause a specific disease process. People might not understand how environmental contaminants move through the subsurface and into groundwater and find a pathway to human receptors in an office building. These are the reasons why expert testimony is required in those sorts of cases. Now, even if expert testimony is not required, it may still be permissible if the offering of that opinion would be helpful to the jury, even if those lay jurors still have some knowledge. So, for example, if we're talking about a product which is alleged to be defective, either because of a manufacturing error, an error in design, or the provision of an inadequate warning, jurors can generally understand that at a very high level. but in order to truly appreciate what the defect is, how it came into existence, and how it may be alleged to have caused injury, that sort of thing may require expert testimony. The same would be true in a property damage case. We all, as lay people, understand how property can be damaged by some adverse event, a car crashing into a house, a storm destroying property, and the resulting diminution or decrease in value. But it may take expert testimony to assist the jurors in quantifying the nature of that damage and the amount of economic harm that it has caused when they are called upon to render a verdict for money to compensate the aggrieved plaintiff. Now, there are circumstances in which expert testimony is prohibited and the offering of opinions should not be allowed by a court. And the first and the most obvious are issues of law. Recall that I told you that the court is the trier of the law in both a criminal and a civil context. Nonetheless, we sometimes encounter experts who want to talk about the existence of responsibilities or moral obligations. The law, however, does not recognize responsibilities or moral obligations. It recognizes only the existence of legal duties, and it is for the court to decide whether a legal duty issued in any particular circumstance. So any expert that would come in and purport to want to talk about the existence of a duty should be precluded. Secondly, there are areas in which there is no commonly recognized expertise. Certainly in a number of the cases that I've been involved with over the years, certain experts have come in and wanted to testify about their belief that the defendants were engaged in some form of a conspiracy against the plaintiffs. And they reached that opinion by simply reading documents and reading testimony that have been offered by other witnesses in the case. But the fact is, the law does not recognize conspiracy as an area of expertise. And accordingly, the court should preclude an expert from testifying on those issues. And the reason is because you don't need an expert to interpret the documents or interpret the testimony for you as a juror. You as a juror are perfectly capable of doing the same thing. And then finally, of course, if we're talking about an area of common knowledge, common experience, common understanding and interpretation, it would not certainly be a required area for expert testimony and probably not even helpful to the jury. As Bob Dylan famously sang, you don't need a weatherman to know which way the wind blows. If you have the ability to hold up your finger, you'll know which way the wind blows. And the same is true with expert testimony. If you're going to be engaged as an expert, it's important at the very outset to understand the nature and scope of your assignment. That is, what you are being charged to do by the attorneys and the parties that have retained you. Because you need to understand precisely what you're going to do and how you're going to approach your task. And in the discharge of your duties as an expert, you must understand and have access to all of the evidence in the case that is going to bear upon your assignment and give you the ability to arrive at your opinions and conclusions that you hope to express to the jury. That means you need to consider and evaluate all of the documents in the case and all of the testimony in the case, whether by fact witnesses or parties or other experts that are going to weigh on the assignment that you've been given. It is extremely important to understand what the recognized and authoritative treatises and texts are in your particular field, because the opponent's attorneys will certainly have access to all of that, and they will use those to cross-examine you, whether in deposition or at trial. And so it's very important that you understand what has been reported in the open literature so that you can take that into account in the discharge of your assignment and in arriving at your opinions. You need to review the reports and the studies that have been published by others with a very critical eye, the critical eye that you bring to your work in the day-to-day practice of your discipline. Whether you are a physician, a scientist, an engineer, a toxicologist, or some other type of expert in your profession, you need to do your job as an expert witness in the same way that you would do it in the day-to-day performance of your profession. If there is prior testimony available to you, either testimony that you yourself have given or others in your field have given on the very topics that you've been asked to testify about in this case, you should have access to that and you should familiarize yourself with that, because I can virtually guarantee you that your opponents will know what that testimony is. And again, it will be used to cross-examine you if there are inconsistencies with what you are testifying to in this case versus what you or others may have said in prior similar cases. It's also important to understand that you have access to your professional peers, whether in the academic or professional environment. There are others in your field whose opinions you value, whose reputations you find stellar, and who you will want to talk with in order to determine whether you're approaching your assignment and the discharge of your tasks in the right way. It can provide valuable insights to you and perhaps steer you in directions that you may not have thought of yourself in order to enhance the performance of your assignment and thereby the credibility of your opinions. And as I said before, and the last point we make here is you must perform your job as an expert in the same way that you would conduct your job in its day-to-day performance. Now, there are a number of basic fundamentals that you should always have in mind when you're approaching your assignment and preparing to be deposed in any case. The date of first contact, when you were first contacted about the case and the nature of that contact. Was it an attorney that reached out to you? Was it the party itself? How did you come to be involved in the case? What materials were provided to you in order to assist you in discharging your assignment in the case? Were these things provided to you by the attorneys? Were these things provided to you by third parties? Or were these things that you pulled up as a consequence of your own scholarship and your own research? You will be asked about all of that. How much time did you spend on the matter prior to offering your opinions, whether at deposition or trial? It's really remarkable how often we encounter experts who are so used to the process and who testify so frequently and so redundantly that it's almost as though they're mailing it in any particular case. And they really don't engage in the intellectual rigor and analysis that one must go through in order to properly discharge their job as an expert. You will be asked about work performed by others in arriving at your opinion, whether these are people working for you or under you or independently of you, but nonetheless work that you are relying on, even though you did not do it yourself. As a consequence of offering your testimony, and after you've heard the questions that are asked of you by your opponent's attorney, you may contemplate that you'll need to do further work in the case before you offer your opinions at the time of trial. And you will be asked about that at deposition, whether you anticipate the necessity for performing further work before you come into court and testify. And of course, you'll be asked to talk about what fees you are charging for the research and the discharge of your assignment and the testimony that you're offering. And those are often very surprising when we find that an expert may have one fee that they charge for the day-to-day performance of their work, and then quite another, typically very much higher fee for engaging in work as a litigation consultant and testifying expert. You'll certainly be asked about what the percentage of your income is that is derived from consulting and testifying in litigation, because there are certainly experts out there where virtually 100% of their professional time is devoted to the performance of expert witness work and very little to the independent performance of their profession. It's also important to understand the breadth of the expertise that you are claiming in any particular circumstance. We certainly encounter quite a number of one-stop shopping or jack-of-all-trades experts, that sometimes we will have physicians who, merely by virtue of having an MD that follows their name, believe that they are qualified to testify about virtually any medical issue that may be presented. But we all know, just by virtue of being alive, that if you are, for example, an OBGYN who engages in the treatment of pregnancy and the delivery of babies, you probably shouldn't be talking about the performance of brain surgery or lung disease. And yet this happens routinely. So it's important to understand what credentials you are actually bringing to the table that qualifies you as an expert to testify in this particular matter. what is the special education and training and experience that you have had that entitle you to render opinions on this subject area? What professional organizations are you members of? Are these organizations that anyone in your profession can join simply by paying a fee? Or is this something that you have to be invited to join or elected to join by your peers? Obviously, the latter has much greater weight in terms of qualifying you as an expert than would simple membership in any organization that anyone could become a member of. And then, of course, what teaching and writing have you actually done on the subject as part of your work in the day-to-day discharge of your discipline? Are you a recognized and published authority in this particular area? Do your peers recognize you and call upon you to write and speak on this subject independent of the work that you're doing in litigation? That is an extraordinarily important qualifier. And then, finally, are you advertising your services as an expert? Do you have a professional website in which you are calling to the attention of the public the fact that you're available to serve as an expert? Many people are doing that these days, usually on one side of the ledger as opposed to the other. And this can be very damaging to your credibility. So one has to take great pains to assure themselves that they are conducting themselves in an independent and objective manner when they try to hold themselves out as an expert. Thank you very much.
Thank you, Kevin. We now would like to invite the experts on our panel to introduce themselves, starting with Dr. Paul Loboto.
Paul, you may be unmuted.
Yes, the little mute button. Thanks everyone for inviting me to speak today. So my background is that I am a medicinal chemist. I have a PhD from Brown University, where I did a lot of research on protease inhibitors, which are potential drugs for cancer therapy. After Brown University, I went into the pharmaceutical industry and worked at a company called Paratech Pharmaceuticals, which developed antibacterial drugs, as well as some preclinical drugs for spinal muscular atrophy, multiple sclerosis, and arthritis. So I say preclinical because they passed all the tests required to enter clinical trials, but lacked the money to do so. So in 2013, the company downsized, and I transitioned from being a full-time employee to having many jobs. So I started consulting, I started teaching, and in 2016, I was contacted to be an expert in a very high-stakes litigation matter between Pfizer and Mylan. And I was contacted because of, well, they found me based on my extensive experience working for Paratech in a class of drugs called tetracyclines. So you might have heard of minocycline or doxycycline. So what Paratech does is derivatize these and improve upon certain properties, like working against resistant strains of bacteria or dialing down the antibacterial activity altogether and focusing more on the anti-inflammatory properties of those drugs for treatments like MS and arthritis. So the type of case I was involved in is called Hatch-Waxman type litigation, and that's where a generic drug company will go after some of the weak patents protecting a branded company's drug. I don't know what happened in the case. It settled a day before it was meant to go to trial, but I got the full experience of writing expert reports, being deposed, and the like. So since then, I've had a handful of cases, mostly to dealing with pharmaceuticals, although I just had a small case recently that I had to give an opinion on whether or not a breathalyzer tests results were due to actual intoxication or drinking kombucha tea. So that was a kind of a fun little case.
Thank you, Paul.
Well,
We would now like to introduce our next expert, Dr. Annette Santamaria.
Good afternoon, and thank you very much for inviting me to participate in this very interesting webinar. I am a board-certified toxicologist. I started my career by having a bachelor's degree in biology and minors in chemistry and psychology. And afterwards, I worked actually for a testing lab where I was analyzing wastewater samples from Baltimore City. And I was promoted to be in the oil division of the lab. So I was testing filters from corporate jets to see if there was any metal breakdown parts. After that, I worked at Johns Hopkins School of Medicine for several years doing pharmacological research. And I did a lot of in vitro work. And during that time, I obtained my master's degree in public health from Johns Hopkins School of Hygiene and Public Health, because I was trying to decide whether I wanted to stay in research, go on for my doctorate in pharmacology or biochemistry. But by getting the public health training, I realized there was just a lot I could do. I really wanted to apply the science that was being done in the laboratories to real world problems and help take that science to different expertise, areas of expertise, so that science could actually be applied. And so I found that consulting provided me with that opportunity because I was able to work on a variety of projects involving either the government or work with attorneys. We did both regulatory work and litigation work. And that was many, many years ago. Now I've been in consulting for approximately 30 years, and I've worked with a variety of very, very sophisticated consulting firms. I also, once I started with consulting, I realized I really wanted to get my doctorate in toxicology. So I went to University of Texas School of Public Health, and I had my doctorate in toxicology. I did in vivo work. Back then, I was wanted to become an expert in molecular toxicology because that was just sort of beginning. And so over the years, my areas where I've served as an expert witness are very diverse. Because of my training at Hopkins, I've worked on pharmaceutical cases, I've worked on environmental litigation matters, and a lot of occupational exposure cases for both individual plaintiffs and or class actions involving pretty much any chemical you can name. So I've been very fortunate to work with a lot of very incredible expert colleagues, either in industrial hygiene or in engineering. And I've been very fortunate to meet a lot of very, very smart and interesting and engaging attorneys over the years that have hired me. So it's a fun field, and it's always challenging, and you're always learning. But that's a little bit about me. Thank you.
Thank you, Annette. Our next expert is Greg Perkins, Pe. Greg, would you like to introduce yourself?
Yeah. As mentioned, I'm Greg Perkin. I'm a mechanical engineer. I graduated from California State University at Long Beach in 1973. I entered into the oil industry. That's a very young picture of me, but I entered into the oil and gas industry right out of high school and worked my way through college. And then after I graduated, I went into the field for 2 years, worked both onshore and offshore in drilling related operation, completion related operations, and those sorts of things relative to oil and gas development, production, refining, those sorts of things. In the mid 80s, actually in the early 80s, I moved from California where I was born and went to college down to Texas, where I am now. And went to work for a large corporation based in New Orleans. And if you remember, that was the time when the oil industry was booming. The rig count was very high, and I was working with a number of different entities to develop our products and manufacture our products and use our products. In the mid 80s, the oil boom went bust, and I started looking for a job. I started consulting out of my house. I did some work overseas for about a year and up in Canada for about a year. And then in the 1986, 1987 timeframe, I was approached by a firm here in Texas who wanted to talk to me about my oil and gas expertise as a mechanical engineer. And so I went down and I talked to them, and they asked me if I had ever given a legal testimony. And I said, well, I've been deposed once or twice in litigation related matters, not necessarily something where I was an expert, but they said, we do expert witness work. And so part of the thing that attracted me to them was possibly getting into the expert witness field, but also too, they bought my consulting business and wanted to develop some products and some technology that I've been working on for a few years. So in about 1987 is when I started working as an expert. I spent about 50% of my time doing that. In the early 90s, that firm got bought. It kind of imploded, and a number of us who worked at the firm went off and started our own consulting firms. I started Engineering Partners International in 1995. We've been in business now for probably almost 27 years. And as a result of Engineering Partners International success, I did start out primarily doing pretty much full-time litigation support. But as we've evolved, the company has grown. We have a number of experts within the firm. Typically in terms of, and I was listening to Kevin's speech with great interest. All the things that he talked about are true. And basically the things that you will experience as an expert that he mentioned are true. It's not for everybody, I've learned. You can have expertise in certain fields. You can have experience in certain fields, knowledge in certain fields. But I've learned too that you have to be able to communicate that knowledge. And as Kevin mentioned, you've got to be able to communicate that knowledge to the layperson. And so that's very, very important if you ever have any intentions to be successful in this field. I taught for University of Texas from 1995 to about 2010, 2011. And then in 2011, we formed a training company in basically an oil and gas company. Was called Energy Training Solutions. And I taught the same subject matters and energy related operations for Energy Training Solutions as I did for the University of Texas. Today, Engineering Partners is, we're not an IBM, but we have a number of consultants. We have a number of people in our firm that do litigation and litigation support. I have probably given close to 400 depositions in my career, and I have probably given almost, I know I've appeared about 75 to 80 times at trial, both in state and federal courts from Hawaii, California, Texas, Oklahoma, Louisiana. So I do know, I've been there and done that. But again, it's an exciting field, and it's something that I compare to working in industry, where in industry I was only doing certain things. But in this work, you're doing all kinds of different things, and that's what makes it challenging. It's what makes it enjoyable, and I certainly appreciate a lot of the people that hire us and that we work with, and we hope it goes on. And by the way, both my sons who graduated from college about 15 years ago are working with me and are also enjoying success as experts. So there you go.
That's wonderful. Thank you, Greg. We are now entering the second half of our webinar today. We've compiled several commonly asked questions to kick off the Q&A before we address the questions that you all have typed into the chat. Our first question is for Paul. Paul, can you tell us what your first deposition was like?
Yeah, I was pretty excited about it. A little nervous, but so I over-prepared for it. I did pretty much nothing else but read over my reports, the opposing experts' reports, read over all of the documents, as many as I could, and I imagined being on the other side and tried to think about questions that I would be asked and made sure that I could answer those questions. But so the thing is that the deposition, the first case, like I mentioned, was based on what I did in industry for 11 years. So, and also the field of tetracyclines is very, very small. So Pfizer was into it, and also Paratech was into it, but there weren't many companies that were. So I was probably a handful of experts, one of a handful of experts that could even opine directly on tetracyclines and had experience with tetracyclines. So the opposing expert, although highly qualified, he hadn't worked with tetracyclines. So, you know, he had to do probably a little more work than I did as far as getting up to speed. But yeah, the deposition was all day. It was roughly about 9 hours or so. And I felt very comfortable during the deposition, and took my time with it. And my lawyer said it went really well. So I was pleased with that.
That's great. Thank you so much, Paul.
You're welcome.
Our next question is for Dr. Santamaria. Given your experience writing expert reports, what tips can you give a potential expert?
Well, when I write an expert report, I make sure that I conduct a thorough review of the scientific literature that is specific to the case. A lot of my expert reports typically involve cases where I've been asked to determine whether there is an association between an exposure to a particular chemical, whether that's in a consumer product, workplace, or the environment, and an alleged health effect in the plaintiff or plaintiffs. So my first task is really to understand dose as a toxicologist and exposure levels that are associated with any adverse effect. And so I'll review the literature, the scientific literature, any government documents that have been prepared on that particular chemical, and prepare a discussion in my expert report about what is known about that chemical. And I'm careful to not just cherry pick either epidemiological or toxicological studies that show that there is no association with that chemical, with that endpoint, because I need to include positive studies that did show an association, if those exist, and explain why or why not, why I agree or why I don't agree with those studies. So I have to give a very balanced interpretation and evaluation of the science. And that's one thing that I really liked about becoming a consultant. Having come from training at Johns Hopkins, you're in your mind, it's drilled into your brain. You need to protect the public no matter what. But in consulting, you're given a chance to say yes or no, there is an association. You discuss this with your client. At that point, they can decide whether they're okay, let's settle the case or not. So at any rate, for my expert report, I conduct a thorough review of the science and then review what the case documents are. What do we know about these individuals? What was their work history? What's their medical history? And were they possibly really exposed to levels that could or could not cause what the alleged health effects are? In addition, we looked at alternative causes. If this person is a smoker and they're claiming lung cancer as a result of an exposure to an occupational toxin, then we really have to evaluate what's the contribution of that potential alternative cause to this individual's health effect. The other thing is I just make sure that I am completely comfortable with everything that I've written in my expert report, so that if I'm questioned about anything in that report, whether it's a study that I've cited or an opinion that I've made, I have to be prepared to completely be able to defend that and justify why I included that study or why I did not. Then also, if I am working on a report where I'm relying upon a colleague or another individual in the case who is an industrial hygienist, if I'm using part of that individual's findings in my report, I make sure that I really understand how he or she arrived at those conclusions, and make sure that I'm comfortable with incorporating that into my report. And And then thirdly, I just make sure that I don't overstep the bounds of what my area of expertise is. As a toxicologist, we have to be a little careful occasionally that we don't make opinions and conclusions that are really in the realm of a medical doctor. And so that sometimes is a fine line because we are asked to look at, an individual's medical records, et cetera. But I really have to make sure that I stay within the confines of my expertise as a toxicologist.
Thank you. Our next question is for Kevin. Kevin, what advice would you give an expert in choosing cases to work on?
Thanks, Ben. This is a very important question for you all, ladies and gentlemen. And the very first point I would make is more or less redundant of what I told you before. You need to stay in your lane. If you are, for example, a board-certified pulmonary medicine expert, and you are approached by an attorney who wants you to talk about kidney disease, you probably want to avoid agreeing to serve as an expert in that case because it's really not your particular area of expertise in the real world. So it's very important that you understand what limbs you are willing to go out on, because your opponent is going to be looking to saw that limb off behind you based on an absence of proper qualifications. So do try to stay in your lane. Number two, make sure that you have free rein to do your job as an expert properly and completely. You'd be extraordinarily amazed how many times we encounter experts who had a halter put on them by the attorneys who retained them in terms of what they were allowed to do in the discharge of their assignment. In other words, they were being asked to serve as an expert and to perform their work in a way different than they would perform the day-to-day practice of their profession. And that is just fodder for cross-examination if you're not doing your job properly and completely. Thirdly, be aware of who you are working for and working with as an expert in the case. I'm not asking you to approach this with a particularly cynical eye, but you do need to be objective and have your eyes open, because not all attorneys, not all litigants are created equal. And you may find that you're working for some people that do not enjoy the best reputation in the world. And you could be tarred with that brush. Your reputation could be sullied as a result of your agreement to work for those folks. So it's very important to understand going in who you're working for, what you're being called upon to do, and why, and whether you can look yourself in the mirror and say, yes, this is an area where I actually can lend value and bring objectivity to this analysis. And then finally, and not least important, is make sure you get paid. You all are professionals. Your time is worth something. It's worth what the marketplace says it's worth. And if you have an hourly rate that you charge for the performance of your work, whether in your profession or as a litigation consultant or expert, you are entitled to be compensated for your work. Make sure that you are working with people who will guarantee that you will be paid for the time and the effort that you have invested in the case.
Thank you, Kevin. Our next question is for an expert. Greg, this question is for you. Why would you choose to not work on a litigation matter?
That's happened very infrequently with me. There have been times where I have been asked to come down to a law office and visit with an attorney or attorneys to look at a file and consider the facts and what happened, what went wrong, potentially who's at fault. There are times when the facts just don't really bear out in terms of where the attorneys really want to go with the litigation. And there have been a few times where I've said, like, I just can't help you. And as Kevin pointed out, we do work with a lot of different law firms all over the country, but there's a lot of them here in Houston, a lot of them in Louisiana, Oklahoma, and what have you. These firms contact us. Some of them we know intimately, some of them we don't. And so in the process of getting to know them, there are times when, the attorneys, as Kevin pointed out, we need to have free reign. We need to be able to get the information we need to do the proper analysis in what we're being asked to do. A lot of times we don't get that. And so it makes it difficult to work on a litigation matter under those circumstances. And we typically let the client know that, you know, if we don't have this information, it's going to be very, very difficult to support this particular position or that particular position. You know, there's one interesting thing I had a few years ago. Actually, it's still going on. It was an intellectual property, a patent, if you will. Baker Hughes had contacted us and wanted us to support them in litigation against Schlumberger. Long story short, it was involving, you know, mechanical tools and equipment that were used for oil and gas production. And the attorneys I was working for downtown in Houston had a sort of a preconceived notion of how this thing worked. And they did provide me with some drawings and some information about how it was supposed to work and what the claims of the patent were and so on. But I kept looking at the drawings and I kept saying, it doesn't work that way. And they said, no, it does work that way. And we went back and forth and back and forth. And finally I said, look, you need to get me with one of your engineers and we'll talk about it. And it turned out that about 2 weeks later, they did get me with one of their engineers and we talked it through on the telephone. And, you know, I was right and the attorneys were wrong. And they basically had to rethink their whole case. So, you know, you got, it's sort of like a moving target sometimes. Sometimes right away you'll know, other times you don't, and you may find out later.
Thank you, Greg. That was very helpful. We're going to skip the next two questions because they have been addressed in part and in whole. Our next question is going to be open for any of our expert panelists. For our experts, did you know what to charge as a first-time expert? Did you get advice from anyone, or was that rate set arbitrarily?
Can I answer that?
Absolutely.
When I went to work as an expert, I worked for a firm, they set my rate. When I left the firm and started Engineering Partners International, I looked at my peers and the peers that I compete with, friends, but yet we're peers, yet we meet each other in litigation and so on. So over the years, it's sort of been something that I look at what my competition or my peers are charging, and that's sort of how we sort of adjust and work with our fee schedules. So, you know, what's the market? What will the market bear, so to speak?
That's been my experience also, so I agree.
Yeah, I just asked one of my friends who's a patent attorney, also a PhD chemist, and she can let me know what to ask for.
Yeah, the other place that you might be able to find some useful information if you're just starting out would be any professional societies that you belong to. They may be able to provide some information about not only rates, but also salaries for your fields.
So I can give a little insight into that, having worked with experts across different industries, backgrounds, expertise. This question comes up, especially if you've been tapped for the first time and you've never done this. It's like, well, I don't know what to charge. You know, I have had experts with 30, 40 years of experience being tapped for the first time with PhDs and like 5 different credentials, you know, highly published. And I ask them, you know, what their rate is. And, you know, they give something that was just like abysmally low because there's just no clue about it, you know. And then when I say, I think you should be in this range, you know, they're like surprised, like, really? That's how much I can charge? And I'm like, yeah, because you're consulting. You know, when thinking about entering into this industry, I always give every expert that I speak to this advice when they're now starting off. If you've never ever done this before, it's okay to give it, you know, a lower rate that is standard for your industry for your first go. The reason being, there's a learning curve in writing expert reports. You know, that's a bit of a process that you've probably not done in the course of your day-to-day, and attorneys have to take the time to work with you in order to construct that the right way to submit to court. Attorneys also have to work with you and prep you for a deposition. You know, you have to be taught how to really just answer questions that's being given, not speaking too much. So there's a lot of hand-holding and learning that happens on your very first assignment. And then after you have that, then you can go to the industry range. And I say this because, I remember this one time I interviewed a potential expert and, went to one of the top universities. This person was just like, I'm just amazing and I'm so good and I'm going to charge $800 an hour. And I'm like, every expert I speak to, most experts actually, I would say, who are relatively new, believe that they're the only ones who are very, very good at what they do. And from where I sit, I can tell you there's never been a case where I didn't have other potential similarly qualified experts who can give an opinion on this. I think the only industry where there was a limit is ink age dating analysis. There's only 5 experts like that with labs in the US, 5. And that's the only industry where it's so narrow. In every other industry, there's always someone. So, when it comes to rates, as Dr. Santamaria said, as Greg said, you do want to speak with your peers. There is a range. There's not like a hard number. Your expertise, your experience, years of experience, the more that you have, the higher you can charge. The more experience you have as an expert consulting, the more you can charge. That usually goes up. But you also don't want to go so high because then you just get priced out and, there's more options for attorneys to select in terms of who to retain on the matter. So you always want to just kind of be in that sweet spot when it comes for that. Also understanding, what to charge. Most of the work happens prior to trial. In fact, I would say it's about 90% of cases settle, Kevin, I think, that don't actually make it to trial. It's pretty high. And so most of the work for an expert happens on the consulting side. So, when it comes to the rates, sometimes, experts are like, should I charge higher for testimony? Should I charge for consulting? Like, well, most of the because when it comes to consulting, you don't want to go so high that, it kind of makes it cost prohibitive for someone to retain your services and just kind of be average there. You can go higher for testimony, but most likely you may not go to trial for testimony. So, these are some of the things to consider.
Thank you all. Those were great answers. Our next question came up at the very beginning of our webinar, and this question is open for any of our experts to answer once again. How did you become an expert witness? It's a very open-ended question, so feel free to chime in.
By accident. Again, I was telling Kevin or Janelle or somebody at the beginning of this that when I was in college and taking my engineering courses, I had an instructor that basically was teaching engineering, and he said something one day about, you could be asked to become an expert witness. And that struck me. I don't know why it struck me, but it did. And then, back in 86, 87, when I was asked to become one, I thought, well, okay, I guess the time has come. Again, it's a challenging field. It's a stressful field, but you have to be able to, weave your way through the goods and the bads. And I will say too, in terms of the earlier question, none of these cases are linear. In other words, you don't start and continue to work on them until trial. They start and they stop. They start and they stop. So as you build your file, as you build more information, as you do the things you need to do as an expert, you need to make sure you have the foundation so that when the deposition time finally comes, the report time finally comes, or the trial time finally comes, you can do your work efficiently and competently.
I also feel that for my track, being in consulting, it was important for me to try to publish in the areas that I wanted to become an expert in, and also to attend conferences and present on that. I tend to look for new areas of potential litigation and learn as much as I can about that. And also just by being a toxicologist and keeping my board certification up, that qualifies me quite a bit as an expert witness.
I've written a number of papers and things, publications as well, but typically in depositions and trial, they always want to know what papers you haven't written. Isn't that right, Kevin?
Oh, absolutely. The literature is one of the greatest sources of examination for a witness, both pro and con. Because if you as an expert have not considered certain things that are out there in the available literature, trust me, you will be asked about it.
You will.
You didn't consider it.
Yeah.
You don't want to include opinions in your scientific publications.
But, I mean, in terms of mechanical engineering, which is a broad subject, which is a broad science, there are things that attorneys can go try and grab and basically attack you with because you haven't written a paper in that particular field or you haven't given a speech in that particular field.
And when that happens, what do you do?
When it happens, you just answer the question truthfully. No, I haven't written a paper in, in that particular field. I'm familiar with it, but I have not written a paper in it. When I was teaching, and I still teach, but not as much with COVID. But when I was teaching, things like topics like safety and risk assessment and hazards, and those apply across many industries. And certainly, those are things that I can talk about. But have I written a paper on job safety analysis? Have I written papers on risk assessment? No, but I have companies and I've worked with people and organizations that use my expertise as a mechanical engineer because I do know about risk assessment. I do know about identifying hazards. I do know about the work process and industry standards. So that's typically how I respond.
Thank you so much. That was very insightful. We are actually open now to the audience Q&A. So if you have any burning questions and you haven't typed them yet into the chat, you can do so now, or feel free to unmute and ask your question live.
While you're doing that, I want to leave you with a little vignette about the importance of integrity in your work as an expert witness, and I'll illustrate it with this story. As an attorney, I was interviewing 3 expert candidates from 3 different firms. And so I asked the first expert, what's 2 + 2? And he looked at me and said, 4. Next day, I asked the second expert, what's 2 + 2? And he said, well, that's a very interesting question. It really depends. Are we talking positive numbers or negative numbers? Because depending on whether it's positive or negative, that would change the answer. Fair enough. Next day, I asked the third expert, what's 2 + 2? And with a smile and a wink, he said, what do you need it to be? So
I know that expert.
Your integrity is paramount above all else when you're working as an expert. Once you lose that, you've lost everything.
Well said.
Thank you, Kevin. That's very well said. We don't have any questions in the chat right now. You can take the stage.
Well, we want to say thank you to everyone. Please, if you have any questions for any of our experts or Kevin or myself, please feel free to reach out to us at any time. We're putting this information out there because we are aware that there's just this lack of information about this industry. You can't just apply to become an expert. Usually it's something where someone has to tap you and once that happens the first time, usually it's easier to get found again for subsequent matters. And, we are passionate about this subject. We are making this a much more efficient process for attorneys to identify experts, for experts to be able to be found for cases. And, Kevin addressed some of it in terms of, did you teach on what information is in your background that gives you the credibility of an expert? So if you haven't already, please create a profile on CambiumConsultants.com. There's, it's a free process. We're really revolutionizing the way attorneys are able to find experts because our system really goes through that background of your CV, of your resume. And though it's on the website, I am going to verbalize it here. It is very, very, very important that that this is not for everyone. We are not just going out for every single person. You really have to have years of expertise doing what you're doing. 10 to 15 being on the lower end. The more you have, the better it is because you can speak on any topic very credibly. You know a little bit of the history of whatever it is you're working, how things have progressed, what's happening today, why it's happening today, because you can speak on what happened 10 years ago. And that's very, very important. And I think that is something that's agnostic to industry, whether it's engineering or the automotive industry, whether you're a sales professional. So it really doesn't matter. We're looking for people who have experience doing whatever it is that you do. So feel free to create a profile. You can reach out to any of us. We'd be more than happy to answer any other questions. And we thank you all for joining us today.
Thank you so much for attending this webinar. We hope you learned a lot from it. And if you're already an expert, we hope you learned something new. Thank you so much for joining us. We are now going to close this webinar.
All right. Thank you, guys.
Thank you.